Hello, and welcome to a brand new season of Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. Trust and Trade is our podcast for seasoned practitioners interested in deep dives into areas of competition, consumer protection, and privacy law, and casual listeners who want to hear from the experts and want more than a tweet or hot takes worth of information. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Healthcare and Pharmaceuticals Committee of the Antitrust Law section. The topic, the Illumina GRAIL merger. Illumina, one of the largest DNA sequencing companies in the world, announced in August 2021 that it would be acquiring GRAIL, a company developing a way to test for multiple types of cancer at the same time using DNA sequencing technology. GRAIL was initially spun out of Illumina in 2016, and Illumina still retained a share of the company when it announced the acquisition. The merger immediately ran into scrutiny in both the US and in Europe. In the US, it was challenged under the Federal Trade Commission's administrative authority, marking the Commission's first vertical challenge since rescinding the vertical guidelines. However, the case was dismissed earlier this year by Administrative Law Judge Michael Chappell. It was the FTC's second in-house loss this calendar year, following the dismissal of the Commission's challenge to the merger between Altria and Juul. The merger fared worse in Europe, where the European Commission moved to block the deal in September 2022, in spite of commitments that Illumina made with respect to making its DNA sequencing technology available to GRAIL's competitors. Today, we'll be discussing how the same deal could fare so differently on either side of the Atlantic, as well as some of the procedural risks that merging parties may face under new European Commission guidance. My co-host today is Bill Batchelor, partner at Skadden Arps in their Brussels office. Bill, who are our guests today?
Thanks so much, Anant, and hello, ABA podcast listeners. Really proud to be part of the relaunch of this series, and what a case we've got for you today, and two fantastic speakers. Really, Illumina GRAIL is the case that has everything. It's vertical, it's innovation, there's procedural niceties, there's litigation as much as you like. And here today, we have two speakers who lived through this process and can give us, within the bounds of what's permitted, an insider's view of what went on. So from one side of the Atlantic, we have Paul Csiszar, director from the European Commission at DG Comp, and his responsibility definitely covers healthcare and life science deals of this kind. And on the other side of the Atlantic, we have Jennifer Milici, partner at WilmerHale and former FTC Chief Trial Counsel. So two excellent speakers for you today. Anant has set the scene. Let me just give a little bit more procedural detail because, hey, we're practitioners and procedural detail is what we live for. So the deal is announced the 21st of September 2020. As we all know, you need to check where you're going to file this deal. Some countries take jurisdiction based on revenue, some based on deal value. In this case, there were no mandatory filings required in Europe because the target GRAIL didn't meet any of the relevant tests. Nonetheless, 5 months later, the EC, the European Commission, asks national authorities if Brussels should take a role in the review of this deal. And for our American listeners who may not be into the real nitty-gritty of the lower end of the EU merger regulation, way back in the mists of time, when the framers of the merger regulation were putting it together, the Netherlands piped up and said, hey, I don't have a merger regulation regime in Holland, but what happens if I see a deal I might want Brussels to take the lead on? And the legislator said, no, that's a good point. We will put in Article 22, which says that even if a deal is not notifiable, a member state can say to the Commission, please take a look at this deal. We think it may raise concerns. And that is duly what happened. So on the 9th of March, France asks the Commission to examine the deal, helped by Belgium, Iceland, the Netherlands, and Norway. In parallel, the EC says, well, it's important that we think about these kinds of deals that may be highly innovative, but would otherwise not be subject to mandatory filing in Europe. And so it issues new guidance on the 26th of March saying, well, let's think about how we should apply Article 22 in those kinds of circumstances. We're talking about companies that may have little revenue today, but perhaps quite a lot of competitive potential. nascent competitors, particularly in innovative fields. The EC accepts jurisdiction in April, and in a decision that was much litigated, went up to the first tier of our EU court process, and the Commission's decision to take jurisdiction is vindicated. I should say that's ongoing and subject to appeal. Some 18 months later, the full merger review is completed, and the EC says, well, we think there's a problem here. We think that it would reduce choice, competition, and innovation for early stage cancer detection tests, and the remedies that we've seen, I'm afraid they're not sufficient to assuage our concerns. 6 days later, we see the administrative law judge reach the view that, well, actually, we don't see so much of a concern. We don't think the evidence has been presented to show us that GRAIL would have been advantage to the disadvantage of competitors, and the remedy goes some way also to assuaging any concern we might have. So there we have the background. I have not done too much damage to the facts, and I'm sure I'll be corrected by our speakers, but let's wade straight in. Paul, I have a slight bias for understanding the EU procedural niceties here, just because they're so important for almost every deal we're doing these days, which touches the innovation space. Perhaps for our listeners, including those not so familiar with the EU, what are you looking for under the new Article 22 guidance? And are you thinking that's going to be a big source of new cases for you?
Yes. Hello, everyone. Greetings to the ABA listeners. Thank you, Bill, for your very good introduction into the case. Just a very quick disclaimer. I'm speaking in my personal capacity, and whatever I say today is not necessarily of those of my commissioner or the European Commission. Getting over with this, I should say, as you correctly recalled, the EU merger regulation indeed grants the European Commission exclusive jurisdiction to review concentrations which has so-called EU dimension. That's the phrase. EU dimension is defined by the application of a combined turnover-based threshold. So Article 22 also, in addition to these thresholds, jurisdictional limitations, when they are not met, also allows member states to request the Commission to examine a merger that does not have an EU dimension, but nevertheless affects trade between member states and threatens to significantly affect competition within the territory of that member state. You referred to the guidance paper. Indeed, the Commission now can accept referrals of certain cases from the EU member states, even where the merger is not notifiable in the referring member states, provided that the merger affects trade between member states and threatens significantly affect competition, and so forth. What does it mean in principal terms? The Article 22 guidance paper allows the Commission to assert jurisdiction in a targeted way over the rare, below threshold mergers that threaten with serious competitive harm. I should emphasize as a general comment that the Commission has no intention to use this as a catch-all device or to create an avalanche of potentially irrelevant cases for the Commissions to review. The decision on Illumina GRAIL will not change this approach. That is really what Article 22 is about. It's a corrective mechanism to ensure that we review all mergers that matter. So under the guidance paper, which, by the way, I recommend everybody reads it, unlike other EU papers and decisions and court judgments which go on for hundreds of pages, this is about 20 pages in plain English, very useful for practitioners, even on the other side of the Atlantic if you have a global deal. So what are those categories of cases which could be appropriate for Article 22 referrals? For example, not surprisingly, these are transactions where the target is a startup or a recent entrant with significant competitive potential. It's an important innovator conducting potentially important research, or otherwise the target is an actual or potentially important competitive force, again, with little or no turnover. It may have access to or controls competitively significant assets, such as, for instance, raw materials, infrastructure, data, or IP rights. And maybe it provides products or services that are key inputs, components for other industries. I would also note that in its assessment, the Commission may also consider whether the value of the transaction received by the seller is particularly high compared to the current turnover of the target. What I can say at this stage, after asserting jurisdiction over one case, the Illumina case, that going forward, the Commission continues to monitor transactions that possibly fall within the scope of the Article 22 guidance, including the digital and the pharma sectors, but not solely for these two sectors. We also work together closely with the member states since we need their referrals in those cases. Now, a couple of words on process. The guidance paper provides for a standstill obligation on the merging companies as of the day on which the Commission informs the companies that a referral request has been made. I should also note that even completed transactions can be subject to post-closing investigation within a 6 months cutoff period that would run when the material facts about the merger have been made public in the EU or otherwise came to our knowledge. The merger parties may voluntarily come forward with information about their intended transactions to seek clarity. Where appropriate, the Commission may, in such cases, give them an early indication that it does not consider that their concentration would constitute a good candidate. Third parties may also contact the Commission, bringing particular deals to our attention, claiming that perhaps those mergers are good candidates for referral. If a referral request is being considered, the Commission has an obligation to inform the parties as soon as possible. However, being informed does not oblige the merging parties to take or refrain from taking any action in relation to the implementation of their transaction. As I mentioned earlier, there's a standstill obligation once they received the notification. And I would stop there. Happy to answer further questions. Thank you.
Thank you very much, Paul. And Jennifer, over on your side of the Atlantic, there were some procedural niceties involved as well, I think. But one of the things that we're always curious about as practitioners is, in practice, even on a deal like this, where perhaps the centre of gravity is in different places, how much interagency coordination would there be with your European counterparts?
Thank you, Bill. And I'm very happy to be here today and happy to be on the ABA's podcast. Thank you for having me. Before answering, I'll make my standard disclaimer and say that I'm speaking on my own behalf. I'm just relaying my opinions. I'm not speaking for the FTC. And of course, I can't reveal any privileged or confidential information. So my comments are my own and based on the public record. And this is all public. The FTC typically cooperates with global agencies that are investigating the same transaction. In a typical case, the investigative teams have regularly scheduled phone calls. They might be scheduled every week. They might be scheduled biweekly. They might be scheduled monthly, but there's something on the calendar, a way to check in. The agencies can't share confidential information with each other in the absence of express waivers by the parties. But even when the agencies don't have those waivers, they do have regular calls in order to check in on the status and process and things like that. That said, and this is very important, each agency makes its own independent decision based on the facts it uncovers in its investigation and based on the applicable legal framework. Generally, the FTC decisions regarding the legality of a merger are not impacted at all by the decisions of foreign jurisdictions, and vice versa. But as you mentioned, when it comes to the FTC, decisions by foreign jurisdictions can have a big impact on the case procedure, on how the FTC goes about challenging a merger. So while the FTC's decision to challenge or not is not impacted by what other agencies do, where it does is impacted. And that's because the FTC typically brings merger challenges in its own administrative court. And those actions are then overseen by the administrative law judge, who is Chief Judge Chappell. However, the administrative law judge does not have the authority to issue preliminary relief. At the end of the administrative process, what the agency will get is a cease and desist order, but there's no preliminary relief. So in a merger where the parties have no legal impediment to closing, if the FTC decides to challenge the merger, then it goes to federal court as well as to administrative court, and it seeks the preliminary relief from the federal court. So it goes to federal court to seek an injunction to stop the parties from merging while the administrative matter is pending. And then what happened in the Illumina GRAIL case, which made it a very different case and unique, is that at the time that the FTC voted out its administrative complaint, the parties were able to close legally and globally. There was no standstill obligation. So when the FTC issued its administrative complaint, it also issued a preliminary injunction complaint. Initially, that complaint was filed in DC, and then it was transferred to the Southern District of California. While that action was pending, a standstill order did come into effect in Europe. And typically, if there is a standstill order that prohibits parties from closing, the FTC does not need preliminary relief, and it does not seek preliminary relief in federal court. In this case, they're no longer able to close. That puts it in the category of cases where the FTC doesn't typically bring complaints in federal court. After the announcement came from the EC and the parties could now had a legal impediment to closing their deal, the FTC moved to dismiss its federal court complaint and to proceed in administrative court. Interestingly, the parties in that case, the defendants, resisted the move to dismiss the complaint against them and sought to have the court keep the complaint, which is a very unusual move. But ultimately, the case was dismissed, and then the case proceeded for the FTC just in the administrative court. And that's, again, just the interaction with the European standstill obligation and how that interacts with the FTC's process, which is different when the parties can close versus when they can't.
Thanks very much, Jennifer. And of course, the postscript to all of this, which is still an ongoing debate, is the parties then do dispute jurisdiction from the EC, proceed to close the deal, and since then there's been a whole separate requirement and also an investigation as to whether that breached the whole separate rules in Europe. Perhaps before leaving the procedural niceties, which really are an entire thesis on their own, maybe just one practical point, Paul. In terms of how you're administering the new guidance, is there a separate team, a bit like the Intelligence Committee in Australia or the CMA, who look out for deals, send letters saying, were you thinking of sending this, of trying to seek comfort from us? How is that set up internally, if you can tell us?
Sure. There are no separate units or teams watching. I think in each sector, those colleagues who are following the sector, the news, what's happening in other jurisdictions, simply pick up these deals or leads to these deals. Again, sometimes third parties come to us, sometimes the parties themselves.
So
Perhaps if I may comment on very quickly, just two sentences concurring with Jennifer on the previous issue, because I would like to emphasize that it became a standard practice that the Commission and the U.S. agencies cooperate closely in the investigations, and it's quite common that the parties do grant waivers for each other. They don't grant waivers with respect to all jurisdictions around the world, but with respect to the two U.S. agencies and the Commission, it's quite rare that we don't get full waivers. And again, as Jennifer said, while cooperating, each agency carries out its own investigation under their own procedural rules, and of course, the decision-making process, whether to start a case or how to assess the case, is totally independent from each other. I think it's very important because there were some accusations that the FTC tried to influence us or vice versa. I don't know, but it's absolutely not the case.
No, thanks very much. And certainly it's an observation in most big deals these days, although perhaps not with the twists and turns of this deal, that you would expect a lot of interagency coordination. You would try to keep people aligned as much as you can. So, from procedure, which, as I say, was all fun and games, to substance. And on substance, there's a lot to talk about as well. Vertical issues are back. We think, but Paul will correct us, we think this was the first vertical prohibition since the guidelines on non-horizontal mergers were published by the EC in 2007. And in the US, vertical challenges have had a checkered history. I mean, we can think about AT&T Time Warner, for example. Perhaps, Jennifer, why don't we start on your side of the Atlantic? What, to the extent you can tell us, what were the FTC's approach to the theories of calm in this case?
Yeah, I think it's important to note that the FTC voted out its complaint in Illumina GRAIL while the vertical merger guidelines were still in place at the Federal Trade Commission. So, and it was a unanimous vote. I think that gets lost sometimes when people are talking about this case and other cases, other vertical cases, that this was a unanimous case supported by all four commissioners at the time. So at the time that the complaint was voted out, the vertical merger guidelines were still in effect, and the theory of harm pretty closely tracked the vertical merger guidelines. The theory of harm was that Illumina was a monopolist in next generation sequencing, and that next generation sequencing was a necessary input to the product that GRAIL was producing and was competing against others to produce in the market. And that's the MSAD tests. So under the vertical merger guidelines, the question would be, does the merger give Illumina the ability and the incentive to foreclose GRAIL's rivals? And that's, the complaint is structured to factually allege that yes, it does. The ALJ, as you mentioned earlier, the ALJ ultimately disagreed with that. I think it's important to note that the appeal from his decision is pending, and while the Commission did withdraw the vertical merger guidelines while this case was pending, when they did so, they indicated publicly continued support for the theories of liability set forth in the vertical merger guidelines, and that the reason for the withdrawal was a dispute about the sections of the vertical merger guidelines concerning the pro-competitive effects of vertical mergers. So there's a dispute in the antitrust bar about whether vertical mergers give rise to pro-competitive benefits like the elimination of double marginalization, and that's the dispute. I think when withdrawing the vertical merger guidelines, the commissioners did still say that they supported the basic framework of foreclosure, ability to foreclose and incentive to foreclose as stating a claim for a vertical merger case. But I think what'll be really interesting here is what the commission chooses to do on this appeal. They withdrew the vertical merger guidelines and did not replace them. There are new merger guidelines that are going to be coming out, I think, either the end of this year or the beginning of next year. In the interim, while those guidelines are in draft form, this case provides a really excellent vehicle for the commission to set forth in detail how it views vertical mergers and how it's going to view vertical mergers going forward and how it thinks courts should view vertical mergers.
Thanks very much, Jennifer. And I was interested, one of the things that caught my eye in the LJ's judgment was the interplay of innovation, forward-looking theories of harm with a vertical merger. I mean, if you think about a traditional vertical merger, you've got a dominant input, you've got a downstream rival. You can see already, yes, I understand how that link could be severed. But was there, maybe I can just make the observation. It seemed to me there was an undertone of this is all so far in the future. How do we know what those links would look like? How do we know what would happen if those links were severed? And you could see perhaps the ALJ struggling with that forward-looking, evidencing that forward-looking theory of harm. Sorry, I don't know if you want to comment on that.
Oh, sure. I was going to say that this dovetails nicely with other priorities of the commission at the moment of re-examining ways to look at future competition and nascent competition. So I think that this appeal really gives the commission an opportunity to explain their thinking on what kind of evidence proves a future competition case.
Absolutely, one to watch, definitely. So Paul, I think both of us perhaps were reacting to Jennifer, thinking, well, ability, incentive, all those ingredients would be ingredients that are very familiar to our side of the world. But perhaps to talk to us to the extent you can about how the EC approached the case.
Yes, indeed. And here I would like to emphasize the similarities between the two approaches used by the FTC and the EC. We applied the well-established framework for assessment of vertical foreclosure, that is, as Jennifer said, looking at the ability, the incentive, and at the end, the effects as well. As to the ability issue, the EC found that Illumina is the, quote, unrivaled supplier, end quote, of the next generation sequencing with no credible alternatives, and both GRAIL and its competitors do rely on Illumina's platform for development of their multi-cancer early detection tests. Specifically, we found that Illumina may be able to refuse to supply NGS systems to GRAIL's current competitors, to increase prices, or to otherwise degrade quality of supply. Based on the evidence collected, the EC could not conclude that the recent and future providers of alternative NGS systems constitute credible alternatives for GRAIL's rivals. So, if I'm not mistaken, even the administrative law judge also found that there would not be any credible alternatives to Illumina's NGS systems in the near future. Where he didn't see the problem was the incentive. So coming to the incentive issue, we should keep in mind that the market for NGS-based early cancer detection is expected to expand rapidly and to become a highly, highly lucrative market. Based on predictions, by 2035, this market would reach more than $40 billion per annum on a global basis. Also, GRAIL's flagship test, called Gallery, while enjoying a first mover's advantage, is not unique. Several players are currently developing cancer detection tests in close competition with Gallery. In light of this and the market potential and the ongoing innovative race, what we observed, the EC has concluded that Illumina would have both the ability and the incentive to engage in foreclosure going forward. As to the effects, the EC considered that stifling innovation competition that takes place at a global level necessarily has an impact in Europe and the 6 referring countries. Moreover, in light of GRAIL's and its rivals' plans regarding future commercialization of their early cancer detection tests, competition at the commercialization stage in the future would also be negatively impacted in Europe, including, again, the 6 referral countries. That's all I can say, given the fact that these are also publicly available, what I just said in our various bits and pieces of public statements, and the rest is, as you know, it's on appeal.
Understood. So one thing that we found in the ALJ's judgment, and that echoes statements you've seen in perhaps other jurisdictions at a judicial level. One might think of Meta Giffey in the UK or a slightly older case, Hutchison in Europe. You see the judges coming to terms with theories of harm that are perhaps not standard ones. They might involve an element of innovation and an element of future gazing. And there are some quite tough statements in Judge Chappell's judgment. Antitrust theory and speculation shouldn't trump facts. We need to see probable and imminent substantial lessening of competition. And also, you do feel a little bit of frustration that facts need to be properly substantiated, and theory alone does not state an antitrust cause of action. I don't know, Jennifer, whether you'd like to react to that, and maybe it goes to this is the beginning of a process rather than necessarily being the end of the process.
Yeah, thank you. I do think that this is better understood as the beginning of the process. The commission does have the ability to review both the facts and the law de novo. I would expect them, like I said, to take this opportunity to really set forth what they think the appropriate framework should be for evaluating vertical challenges going forward. But then the commission's decision is also not the last word. One of the features of the FTC's administrative process is that following a decision by the commission, the respondents can appeal to a circuit court of their choosing. So this question of what is the proper way to analyze vertical mergers and what kind of evidence is sufficient very well might end up, at an appellate court within the next year. Um, I also think that the question of, well, what kind of evidence is sufficient is one that we're seeing play out in district courts as well. There just isn't the kind of case law that built up over decades and decades that there is in horizontal cases. There is not a presumption that does, like there is in horizontal cases, that does kind of a lot of the work of identifying which cases a court should really be concerned about. Um, and I think, one of the things in the ALJ's decision in this case is that, while he agreed that having the incentive and the ability to foreclose are important, he seemed to think that 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 you have to have both. The merger has to increase both. And in this case, as a monopolist in NGS sequencing, Illumina already has the ability to foreclose GRAIL's rival, and it already owns a piece of GRAIL. So I think to the ALJ, that meant that the merger didn't really impact the ability to foreclose, and didn't create an incentive where one didn't exist. So in some ways, the ALJ's decision on those points is really specific to this case, right? I don't think that there's a ton of cases where where a monopolist is buying a downstream company of which it already owns a piece. I think this is pretty fact specific, but I also think that complaint counsel in their appellate brief has taken that head on and says that the ALJ is misunderstanding the law, and that for vertical cases, you really don't need to show that the merger is the sole basis for the incentive and ability to foreclose.
So thanks so much, Jennifer. And just to show this case really is a vehicle for almost every hot topic, we come to remedies. And remedies also exciting to my mind. We see some jurisdictions setting their faces against non-structural remedies, so behavioural remedies, even in vertical mergers. That can be a challenge because, well, if part of the problem is you're severing a link, then offering to reconnect, that might be seen as a remedy. The EC is more flexible, I would say, in terms of creating a remedy to fix the problem. But here, Paul, you looked at a potential offer in terms of licensing third parties. But after market testing, the Commission comes back and says, well, we don't think that that's sufficiently robust. Not to put words in your mouth, but to say that we don't find that sufficiently satisfactory. We've seen a couple of cases recently where there has been a little bit of divergence on remedies. So certainly important for our listeners, I think, if there's anything you could say about where your current stance is on behavioural remedies, should we take this as being a hardening of the stance, or is it really you've got to have something that fits the facts?
Yeah, I mean, to some extent, I don't like the simple division of remedies, behavioral and remedies, because there are bad structural remedies and good behavioral remedies. Although statistically, probably 95 or 99% of good remedies are structural, and the behavioral remedies sooner or later have some problems. The question is whether we discover them early enough. And a little bit more seriously, I think there are some differences from time to time between the agency's practice on remedies. I think the principles are very, very similar, which I will reiterate in one sentence in a second. I would just say that we have a formal market test obligation. We market test the remedies, and And when a remedy is relatively borderline-ish, and it receives a positive market test, we usually have no basis to block that deal, or at least we think we shouldn't block that deal, and perhaps that leads to sometimes to slight differences. But I think the similarities are, and if you look at statistically on the cases, 9 out of 10 cases or 19 out of 20, we concur. The basic principles that remedies must be effective, must remove competition problems in their entirety on a lasting basis with the requisite degree of certainty, and they must work in practice. And often, behavioral remedies don't meet this standard. Now, as to Illumina specifically, we assess the case under these principles, under the applicable legal framework, what we have. We also market tested Illumina's proposed remedies with many relevant market participants, both upstream and downstream, other experts as well, academia. And I must say, we received an overwhelmingly negative feedback on the remedies. A little bit more specifically, as to the upstream commitments, the Commission has found that the proposed patent piece would not have been sufficient to establish BIG as a credible alternative supplier for GRAIL's rivals in a timely manner. This is because the patent piece was limited in duration, only 3 years, did not address all concerns around BGI as a suitable supplier, such as relative lack of track record and support network, and so forth. As to the downstream commitments, the open offer, the Commission has found that the open offer requires Illumina to comply with a set of complex behaviors that run counter to its interest in an equally complex market. Once we found incentives, Moreover, it was not possible for the open offer to cover all possible strategies Illumina could conceivably employ to favor GRAIL and foreclose its rivals. And the Commission has simply identified several ways in which Illumina could potentially evade the terms of the open offer. Last but not least, like most of the time, in cases of behavioral remedies, when you have a problem with them, the open offer would be quite hard to monitor and enforce, which again takes us to how certain and how robust these remedies will be in the future. I think you had a second question, if I'm not mistaken, regarding licensing, excess remedy. Exceptional cases, we accepted them mainly in the context of other remedies as well, under specific circumstances. Even when an IP would be the key of the remedy, a sale of that IP and license back would be better. Generally, we have a problem with licensing because it creates an ongoing relationship between the merging parties and the remedy taker, which is not ideal. It gives rise to disputes. So again, it's a somewhat tall order, and I think the onus is on the parties to make a clear, convincing case that a mere license would work in a particular case, short of divestment or sale of the IP and license back.
Yes, thank you. And Jennifer, obviously a different outcome in the US. I was interested that the ALJ considered the remedy as part of the substantive analysis. Maybe that's just I don't know enough about US practice, but is that common when you get to court?
I think that what we're seeing right now is a real dispute about what role behavioral remedies, unilaterally adopted behavioral remedies, should play in litigation. Certainly, the administrative law judge here took it as a market fact and said that that's the market in which this open offer exists, is where complaint counsel has to prove competitive effects, has taken into account that. In their appellate briefs that have been filed in the last couple of weeks, complaint counsel argues that the administrative law judge was wrong to view it that way, and that the open offer was in fact a remedy proposal on which the respondents bore the burden of proving that they remedied the competitive problems. So again, this is another place where we'll be able to find out soon enough how the commission thinks unilateral behavioral remedies like this should be treated in a Section 7 analysis. And I'm looking forward to seeing that. We certainly have seen courts take the view, including in the other vertical cases you've mentioned, have taken the view that they are market facts. And from what commissioners have said publicly from the FTC, I do not think that that's how they think of them. And this will be an excellent opportunity for the commissioners to really set that out and clear that up.
Fantastic. Jennifer, Paul, what a fantastic roller coaster ride through a really, really interesting case and how it unfolded both sides of the Atlantic. Anant, I think we've left our audience with a fantastic podcast. I think we're ready to wrap up.
This has been great. So, Bill, so many intricacies, both procedurally and substantively, in Illumina GRAIL. What would you say are the 3 key takeaways for practitioners?
Well, it's as if we hadn't prepared this at all, but I do happen to have 3 takeaways. And my first is, when you're doing your race around the world to check where your deal should be notifiable, just think you might receive an Article 22 letter from Paul or one of his colleagues. So do think about the EU. Are you going to fall within paragraph 19 of their admirably short guidance on how Article 22 works? I think, secondly, verticals are back. Verticals are definitely back. It's considered an important area for enforcement practice. And I am fascinated to see where the case law will land, where you have a speculative, forward-looking IP innovation type case where current harm is not obvious, future harm is possible. Where will the courts land in terms of how much evidence it will be required? And finally, when you go to offer your remedy, think about the market test. When it goes out to market, when Paul asks the industry, well, would this work for you? Is this feasible in practice? What's their feedback likely to be? Because it needs to be robust. Otherwise, Paul is not going to give you the benefit of the doubt.
Well, let me echo what Bill said. Paul, Jennifer, thank you so much for being on the podcast. This has been an outstanding discussion. Bill, thank you for co-hosting. And you're a natural at this. You're fantastic. So this has been great. To our listeners, we encourage you to subscribe to the podcast on your platform of choice. And we'll see you next time on Trust and Trade.